Hello, good evening once again. Ayan, sige. Okay, so we'll try to finish. We'll try to finish conditions and warranties uh, tonight. So we'll tackle 1556 to 1581. So so we've started with conditions and warranties before, and we've ended with a warranty against eviction. So we'll continue with warranty against eviction, specifically Article 1556, which speaks about partial eviction. So what happens when there is partial eviction? First, we determine, okay, sabi dito, should the vendee lose by reason of eviction a part of things of such importance in relation to the whole that he would not have bought it without said part, he may demand rescission of the contract. So, in case of partial eviction wherein the thing is of such importance, one remedy is rescission. That's the first part. But with the obligation to return the thing without other encumbrances than those which he had when he had acquired it. He may exercise this right of action instead of enforcing the vendor's liability for eviction. So, sabi niya, there is a second remedy. Kung ayaw mo ng rescission, you can go for enforcing the vendor's liability for eviction. So, before we proceed to the third paragraph, let's discuss the first and the second paragraph. So, ang sabi, in case of partial eviction wherein the part of the thing which is lost is of such importance that the buyer would not have bought it if wala yun. So, ibig sabihin, this is a significant part or significant component of the product that you are going to buy. So, if wala yun, hindi mo siya bibilhin. So, if that's the case na hindi mo siya bibilhin, you can ask for rescission. And of course, when we say rescission or in other words, cancellation, pag pinakancel mo yan, okay, yung contract, ibig sabihin, ma-cancel. Ibig sabihin, mawala yung contract. Okay? So, if therefore, the seller has already delivered the thing, of course, the seller had delivered the thing. Why? Because you already lose. The vendee lose, sabi niya, a part. Okay? Ibig sabihin, na-deliver na sa'yo. So, kung you'll go for the first remedy, which is rescission, you are going to return the thing. Sabi mo, exercise mo ang rescission, papakancel, so ibalik mo ngayon yung thing. And ibabalik niya naman ngayon yung bayad if proper. Okay? Second remedy naman, you can enforce the vendor's liability for eviction. Ibig sabihin, in a suit or in a case. Okay? That is the only way that you can enforce the vendor's liability in a suit or in a case. But, however, sabi ko nga, under the law or under our practice, we highly recommend not going to court. Why? Because it avoids the parties their costs. Yung cost ng abogado, lahat yan. Okay, imagine you will pay and then you will pay for the damages, for the return of the thing. Tapos dadagdagan mo pa ng bayad ng abogado. Every appearance may bayad, every papel na gagawin may bayad, every firma may bayad. So, yun yung may iwasan mo if you settle it outside the court. Okay, so in case of partial eviction, two remedies, rescission and enforcement of vendor's liability for eviction. Ito, yung sabi niya dito, if it is of such importance na hindi mo siya bibilin, if wala yung part na yun. But, if yung partial eviction mo is minimal, okay, or bibilhin mo pa rin, you cannot exercise this thing, this Article 1556, okay? Kasi this Article 1556 only applies when the thing is of such importance that it will influence your decision to buy this thing. Okay, let's proceed to the third paragraph. The same rule shall be observed when two or more things have been jointly sold for a lump sum or for a separate price on each of them, if it should clearly appear that the vendor would not have purchased one without the other. So same principle that we will apply. Parang we are considering these two or more things as a whole, diba? Meaning that you will not buy one without the other. Okay? So yun yung so the rule on partial eviction will apply not only in case of missing parts, okay, missing parts or missing significant parts, but also in cases wherein two or more things have been jointly sold. Okay. Ito, we've discussed this one. Yeah, we discussed that one. Article 1557, the warranty cannot be enforced. This one I have discussed last meeting. Until a final judgment has been rendered regarding what? Regarding eviction. Okay, meaning whereby the vendee loses the thing acquired or a part thereof. Meaning the judgment for eviction has become final. Okay. If it has become final, then that's the time that that you can make or we can enforce the vendor's liability or the warranty. Okay. But if the eviction, let's say for example, the judgment for eviction, meaning, sorry. Yeah. Okay. Just like our previous example, A and B. A sold the land to B. B now occupies the land. After a year, C appeared and filed the case against B. Okay. And this is for eviction. Okay. Of course, naturally, B will ask that A may be included in the suit or in the case. Okay. So if therefore, during the court proceedings, okay na, judgment came out and B is evicted, okay, the judgment is not yet final. Okay, it's not yet final. Okay, the judgment will become final after lapse of, originally during our time in law school, it's the lapse of 15 days. But I think nag-change na ito. Okay, so meaning within the judgment will become final after 15 days. So, within 15 days, ibig sabihin yan, within 15 days, hindi pa siya final. Anong ibig sabihin nun for B na na-evict? Okay, for B na na-evict, he can file an appeal. He can question the decision. So, if B, within 15 days, filed an appeal, then the judgment is not yet final. Okay? Kapag may decision na dun sa appeal, may judgment or may decision na sa appeal, okay, B can still file or seek another remedy. So, hanggang sa makarating sa Supreme Court. So, usually, if this originated in the RTC, okay, B can appeal to the Court of Appeals. Yan, first appeal. And later to the Supreme Court. Okay, can appeal it again. That is the remedy in law. Okay, so hanggang tumaas yan sa Supreme Court, kung nag-a-appeal siya, hindi magiging final yung judgment. Okay, but if nag-lapse yung days prescribed by the law, or yung sa amin noon, 15 days, Okay, ibig sabihin, after 15 days, walang final na appeal, the decision becomes final. Therefore, you can already enforce warranty. Okay. Article 1558, the vendor shall not be obliged to make good the proper warranty unless he is summoned in the suit for eviction at the instance of the vendee. Meaning, just like our example a while ago, okay? Just our example a while ago. Si C, kakasuhan niya si B. Okay, in court. Ngayon, ang sabi dito, the vendor, which is A, is not obliged to make good the proper warranty. Why? Because the parties in the case is only B and C, di ba? As you can see, B and C lang. Si C, kinasuhan niya si B. Okay? Unless, sabi dito, he is summoned in the suit for eviction at the instance of the buyer, the vendee. So, meaning, B, okay, can implead A. Okay, why? Para kasali na siya considered na siya as a party to the case. And in that case, the vendor may now be obliged depending on the decision of the court. It's not always naman it's not always naman when there is a claim for warranty, always vendor is liable. Okay, it depends upon the circumstances of the situation. Okay, depends on what you can prove or what you cannot prove. Di ba? Ganun lang naman siya. Okay? Sabi nga natin, just to give you a little hint of the complexity of practicing law. Okay? The universal truth or the general truth or the truth as we know it does not really equate to what you can prove in court. Meaning, there is what we call legal truth or judicial truth. Meaning, there are truths or facts that you can prove in court. And there are truths or facts that you really cannot prove in court. Diba? To give you a clearer understanding, let's say, for example, in a homicide case or in a murder case, okay, the setting is nighttime in an area wherein no one is present and no one may be able to hear anyone screaming. Okay? And there is the perpetrator or yung accused or yung criminal, no matter what you call him. And then in that empty area wherein you cannot be heard whether you scream or not is the victim. Okay? Now, if this perpetrator or criminal killed this victim, okay, and he cleans his mess, okay, he erases all the fingerprints, he burned the body. After he burned the body, nilibing niya yung mga remains which is sunog-sunog na. Okay? The first thing there is how will you prove that this person is the one who killed the victim? Provided na wala namang nakita doon sa area na yun. It's nighttime and no one may be able to hear you. Okay? Those are the complexities in law. Just like in a normal civil case, gaya nito sa warranty, you have to prove that you have a claim. I-prove mo na may claim ka for warranty. If meron nga, you must prove that in court. It doesn't guarantee na kung meron, automatic magkaka-claim ako. Hindi. That's why there are lawyers because they are the ones who will prove that in court that you really have a claim. Because the vendor or the other party, yung kalaban mo, will always deny your claim. Okay? They will not admit to your truth. Okay? Yes, sir, attorney, totoo ba yung sabi ng lawyers are liars because they know the truth, yet they twist the truth? In this example, okay? In this example na lang. Ito na lang na example na to. Okay? Yan. Let's say, for example, the family of the victim. Okay? Of course, they don't have any idea who did this crime. But they know some persons na kagalit nitong wait. Sorry for that. Okay? Now, the family knows a lot of persons na kagalit nitong victim. Okay? Now, let's say, for example, finailan nila yung isang tao. Okay? Itong tao na to, of course, he will seek the services of a lawyer. Diba? He will seek the services of a lawyer. This lawyer does not know the truth kung ano ba talagang nangyayari. What he knows is, merong na-file na case dito sa taong to, and this lawyer, okay, is bound by law and bound by his ethics and by his code of ethics that he is to defend his client. Okay? There are some instances, and this is the truth. Okay? There are clients that will not state the ultimate truth. Okay? Kasi, just like a normal person, di ba? Ang tendency, there will always be two sides of the coin. Di ba? Mayroong side A, mayroong side B. Okay? Kadalasan, kapag nagkikwento ang isang tao, of course, napapansin niyo to, human psychology. Okay? Mostly ng kinikwento niyan, favorable sa kanya. Favorable sa kanya, favorable sa kanya. Nandito ka, you don't know the story. Okay, so what is being stated to the lawyer, yun lang yung mga gamit ng lawyer. Okay? So, layo na pinuntahan natin, but okay, but just to clear na, there are things that you can prove and you cannot prove in court. So does that mean na if you have a claim, matik meron kang claim. You have to prove that in court. Okay, hindi ka agad na okay, vendor, liable si vendor under the Civil Code of the Philippines. Yun sa sales namin, sabi ni attorney, liable si vendor. Yes, liable si vendor if you are able to prove that the vendor is really liable. Okay? Ganun siya. Article 1559, in relation to Article 1558, sabi dito, at the instance of the vendee, he must be summoned in court. Ganun din dito, the defendant vendee shall ask, okay, that the vendor be made a co-defendant. Ibig sabihin, naturally, just like our example kanina, ang kinasuhan lang ni C, si B, okay, B now the vendee, at the instance of the vendee, he can now implead A para tatlo sila sa case. Okay, para ultimately, hindi si B ang liable para may shift niya yung burden kay vendor who is the one really liable because of warranty against eviction. Okay? Article 1560, the last under warranty against eviction. But this one is called warranty against uh, non-apparent servitude. Warranty against non-apparent servitude or warranty against non-apparent burden. Okay, we'll discuss this slowly. If the immovable, stop right there. Hindi basta-basta property, immovable lang. Land, building, yan. Immovable lang. Okay? Sold should be encumbered. Okay? Ibig sabihin, mayroong burden. Anong klaseng burden? Any non-apparent burden or servitude. Meaning, when we say non-apparent, from the word itself, non-apparent. Hindi kita. Hindi apparent. Okay? Parang ano siya, hidden or hindi siya obvious, di ba? Not obvious. Okay? Not mentioned in this agreement of such a nature that it must be presumed that the vendee would not have acquired it had he been aware thereof. Okay? Meaning, kung si buyer, aware siya na merong non-apparent burden or servitude, okay? Then, hindi niya sana bibilhin yun. Okay? So, ano ang remedy ni buyer? Itong remedy niya. He may ask for the rescission. Okay? Rescission of the contract unless, okay, he should prefer the appropriate indemnity. Meaning, under Article 1560, first sentence, okay, if the property is an immovable property and is sold and it has a non-apparent servitude, okay, and the buyer would not have bought this one had he known that it has a non-apparent servitude. Sabi ng 1560 first sentence, there are two remedies. The buyer may ask for the rescission of the contract or indemnity, or in other words, damages. Okay. Ibig sabihin, he's not gonna cancel the contract. He'll accept the property, but you pay me daños. You pay me damages. Okay? Those are the two remedies under the first sentence of Article 1560. Rescission or indemnity or damages. Neither right can be exercised if the non-apparent burden or servitude is recorded in the registry of property. Okay? So in short, just like what we did here, the general rule, okay, the general rule is that in case of an immovable property sold with a non-apparent servitude and the buyer had not been aware of it, okay, or he would not have bought the same if he had been made aware thereof, there are two remedies generally, okay, rescission and indemnity or damages. Except, okay, except if the non-apparent servitude is recorded in the registry of property. How can we know if the property is recorded in the registry of property, since the property subject of Article 1560 are lands or building You can see it from the title. Sa title, sa likod, specifically sa likod ng title, kapag merong encumbrances or merong mga burdens or servitude, ang isang immovable property, naka-annotate yan sa title, sa likod, nakalagay dyan. Kita mo dyan, merong non-apparent servitude. Kung ano yan, discuss natin naman. Okay? Exception to the exception. There is an express warranty that the thing is free from all burdens and encumbrances. Okay? Okay? So, gets na? General rule, yung first paragraph pa lang tayo. General rule, sale of immovable property na merong non-apparent servitude. Okay? That the buyer would not have bought that property in case he is aware thereof. There are two remedies, rescission and indemnity or damages. Except, therefore, you cannot exercise rescission and indemnity or damages if it is recorded in the registry of property. Why? Because recording in the registry of property or yung tinatawag nating registration. Registration is equal to knowledge. Okay. Registration is equal to knowledge. Meaning, even if you are not aware that there is a non-apparent servitude, there is already a presumption that you know it because it is already registered in the registry of property. And that registration under the law and under the jurisprudence is a notice to the public. Diba? Notice yan sa public. Okay? Sabi nga natin before, we compare this to the law. Okay, if you are already reading some law materials, you can encounter a basic law principle that ignorance of the law excuses no one from compliance therewith. Meaning that if, let's say for example, pinanganak ka lang ng 2000s, 2001, 2002, okay, and meron kang na-violate na law na ginawa noong 1990, 1992, sasabihin mo yon, I cannot be liable because I am not aware of that law. No, that is not how the law works. Okay? The moment that the law is published, okay, and it has taken effect, you are presumed to have knowledge of that law. Kahit pa hindi mo alam yung batas na yan, you are presumed to have knowledge of that law. That works the same way in this article. Meaning when we say registration in the registry of property, that is already notice to you. That is already, there is already a presumed knowledge to you. Okay? Exception to the exception, when there is an express warranty, ibig sabihin, you guaranteed. Nonetheless, you guaranteed na walang burdens yan. Walang encumbrances yan. Even if the registered sa registry of property, ginaranti mo, di ba? Na wala yang non-apparent servitude or burden. Okay? Timeline, within 1 year from the execution of the deed of sale, the vendee may bring the action for rescission, yung remedies natin, rescission and indemnity or damages. Okay? 1 year having elapsed, he may bring only an action for damages within an equal period to be counted from the date on which he discovered the burden or servitude. Okay? So kung within 1 year, we can have two remedies, rescission and damages. After 1 year from the date you discovered the burden or servitude, ano na yan? Action for damages na lang. Okay? I hope that's clear. Servitude, under the law, ito kasi madidiscuss nyo yan sa property na subject sa law. Servitude is an encumbrance imposed upon an immovable for the benefit of another immovable belonging to a different owner. I don't know if sa inyong class ko ito na-discuss, but I'll give an example of a servitude or an encumbrance para maintindihan nyo ng gusto. Okay? Bago tayo po mag-proceed sa non-apparent and apparent encumbrance. Okay? This house and this lot, we have two lots. This is the national road or this is the road. Tapos dito, sabihin mong river ito. Tapos ito, sabihin mong public government property. Okay? This lot here is owned by Mr. A. This lot here is owned by Mr. B. Okay? Now, Mr. A can access the road anytime. Why? Because he is adjacent to the road. Katabi niya lang yung road. Diba? He can access the road. How about, ito kunwari, bundok-bundok to. Oh, ayan. Ito tubig. Ayan. How about Mr. B? How can B access the road? This is a river. Okay. This is a government property. Sabihin mong building yan. How can B access the road? Paano kung may sasakyan si B? Okay? Paano siya dadaan? Paano siya makaka-access sa road? Okay? Under the law, the property of A is going to be burdened. Kakaroon ng burden yung property ni A. Ang tawag natin sa burden na yan, that is called a right of way. Yan. Kung na-experience nyo na yan, yung mga problema sa lupa, yung daanan, ayan, right of way. Ibig sabihin, si B, being the beneficiary land, kasi siya yung magbe-benefit sa right of way, okay, will use the portion of the lot of A. So, kawawa si A. Kaya siya tinawag na burden. Di ba? Sabi natin kanina, non-apparent burden or servitude. Burden siya kasi nga, imbes na parehas kayo ng lupa. Imbes na parehas sila ng lupa, hindi na. Kasi nga, yung isa is na-convert na into a right of way. Naging kalsada na. This one is specifically for B para ma-access niya yung road. That is given under the law. Right of way. Burden. Hindi burden kay A, kundi burden sa immovable, sa property ni A. I hope naintindihan nyo. May mga, okay? Burden sa property ni A. Okay. Ngayon, itong right of way, I'm sorry for that. Okay. Itong right of way is an apparent burden. Why apparent? Kasi kitang-kita mo eh. Kitang-kita mo yung daan dyan eh. Okay? Kitang-kita mo eh. So, apparent siya. How about yung sabi sa Article 1560 na non-apparent burden or servitude? What is that? An example will be, a good example is dyan sa may airport natin. Dyan sa may airport natin, you noticed the house are limited to a certain height or first floor lang yung mga bahay. Even the constructed Robinson is only at a certain height, because during the time when they were negotiating that the building of Robinson, di ba, Robinson, usually towering ang mga building niyan. Okay? But since they are near the airport, okay, let's say for example, this is the airport, lahat ng building na near sa airport will have to be burdened. Will have to be burdened na hindi nila pwedeng i-exceed at a certain height lahat ng constructions nila. That is what you call non-apparent burden or servitude. Hindi mo kita, pero pag nalaman mo na may airport dun, kaya pala. Because may airport, mayroong burden sa mga katabing lupa. Hindi sila pwedeng mag-exceed at a certain height. Madami tayong non-apparent burden. Yung iba kasi hindi niya alam. Let's say for example, non-apparent burden ng light and window. Yan, sa mga magkakapit-bahay. Okay, sa mga magkakapit-bahay. Say for example, lupa itong mga to, magkakadikit. Tapos, merong mga bahay-bahay dyan. You are not parang meron burden with regards to constructing a window. Okay, not to the point that you are already able to see your neighbors' private businesses. Okay, madaming mga burdens yan. Okay, so that is non-apparent burden. I hope that's clear with you guys. Okay, we're done with warranty against eviction. We'll go to warranty against hidden defects or encumbrances upon the thing sold. The vendor shall be responsible for warranty against hidden defects, which the thing sold may have, should they render it unfit for the use for which it is intended, or should diminish its fitness for such use to such an extent that, had the vendee been aware of, he would not have acquired it or would have given a lower price for it. Okay? But said vendor shall not be answerable for, of course. Okay? The first part talks about in case there exists a hidden defect or a hidden fault. Okay? There is hidden defect or hidden fault wherein it would render the thing purchased unfit. It cannot do its purpose, or it may do its purpose but its fitness has been diminished. Okay, na kung aware si buyer, kung aware ka na buyer, either hindi mo siya bibilhin or bibilhin mo siya pero at a lower price. Diba? So, let's for example, bumili ka ng, ano kaya magandang example? Cellphone. Akala mo iPhone. iPhone 13 Pro Max. Yeah. Okay. Tapos pag open mo, okay? Pag open mo, ano pala? Korean version. Ano yun? Yung mga copy version. Okay? That means that if you had known that before you bought that property, hindi mo siya bibilhin because you really want that iPhone 13 Pro Max. Or, bibilhin mo man siya at a very low price or a lower price. That is warranty against hidden defects, or that is hidden defects. Okay? But, sabi dito sa second paragraph, said vendor shall not be answerable for patent defects. What do you mean when we say patent defects? These are the defects that are already recognizable, or they are very obvious. They are patent. Di ba kitang-kita? Or those which may be visible. Kitang-kita na eh. Posibleng hindi mo pa makita na copy ang phone na yan, di ba? Okay? Ganon. Or, ano pa yan? Or for those which are not visible, so, ang sabi natin, hindi liable si vendor kung vendor shall not be liable if patent in defect or something that is already visible to the eye, or even if not visible, provided that the vendee is an expert who by reason of his trade or profession should have known them. Okay. So under Article 1561, if we read the entirety of this article, the vendor is liable in case of warranty against hidden defects, meaning these hidden defects would render the thing unfit for the use that it is intended, or should diminish its fitness. Had the vendor been aware thereof, he would not have bought it, or he would have bought it at a lower price. And the second part, the vendor shall not be liable if the defect is patent or the defect is already visible, or if, okay, the defect is not visible, provided that the vendee is an expert and should have known it by reason of his trade or profession. Okay, an example of that, let's say for example A and B. A sold the land to B. B has already been engaged in the buying and selling of land or real estate properties for 15 years. So we can already see that B has the know-hows, diba? Or you can already be considered as an expert with regards to the buying and selling of real estate properties. That if later on, mag-claim siya ng warranty against hidden defects, okay, or hidden faults, hindi na sa kanya ang batas. Why? Because he is already an expert, and by that, we mean that by reason of his experience in the trade or in the profession, he should have known those hidden defects or encumbrances. Okay? Sorry. That's Article 1561. Yan. Requisites of hidden defects. Take note of this one. Of course, defect must be hidden. Of course, diba? It exists at the time of the sale. This is according to jurisprudence. Must ordinarily be excluded from the contract. Why? Because we have discussed before that warranty against hidden defects is an implied warranty. Must be instituted within the statute of limitations or prescription. This one, we will encounter mamaya-maya sa last part. Okay? With regards to the prescription, or meaning hanggang kailan mo siya pwedeng i-file. Okay? Since hidden defect yan, magi-start yan from the day of discovery. Siyempre, kung kailan mo madi-discover yung hidden defect, hidden nga eh. Hindi mo alam yan. From the day na ma-discover mo yung hidden defects, meron kang time na mag-file ng action for warranty against hidden defects. Article 1562. In a sale of goods, there is an implied warranty or condition as to the quality or fitness of the goods as follows. Where the buyer expressly or by implication makes known to the seller the particular purpose for which the goods are acquired. And it appears that the buyer relies on the seller's skills or judgment. Then there is an implied warranty that the goods shall be reasonably fit for such purpose. Ito din yung tinatawag nating warranty on merchantability, di ba? Parang ganun. Merchantability. Meaning, there is an implied warranty, okay, that the thing that you are going to sell is for the purpose that it should have been used. Okay, and because of that purpose that it should have been used, dapat reasonably fit siya kung saan siya talaga gagamitin. Let's say, for example, a broom. Di ba? Ang broom pang walis. That is the purpose. Kaya mo siya bibilin kasi magwawalis ka o gusto mo magwalis. Di mo naman yan bibilin kasi gusto mong paluin yung mister mo or yung boyfriend mo pag meron siyang kasalanan. Okay? That is the purpose of it, and because of that purpose, dapat fit siya dun sa purpose. Warranty and merchantability. Okay? But where the goods are bought by description from a seller, okay? Since they are brought by description, so kung paano siya na-describe, dapat ganun din siya. Meron siyang implied warranty din that the goods shall be of merchantable quality. Meaning, kung paano siya ni-represent na di-describe, ganun din dapat siya kapag nabili mo. That is an implied warranty. It need not be stated in the contract. It need not be present in the contract. That is an implied warranty. Yan ang implied warranty on merchantability. Okay? Meaning that a particular thing that is sold for the general purpose or the ordinary purpose for which it is to be used. Hindi mo naman binenta ang, let's say, for example, baseball bat. Hindi mo naman binenta ang baseball bat for the purpose of not using it as a baseball bat. So generally, kapag binenta mo yan, of course, ang presumption mo, gagamitin niya pang bat, hindi pang bat ng sasakyan o ng mukha ng taong kaaway mo. Diba? Ganun ang gamit yan. Implied warranty of merchantability. Okay? There is also no implied warranty on second-hand articles. Of course, if that is known that is a second-hand thing, okay, there is no implied warranty on that. Why? Because the mere knowledge that that thing is second-hand Ayan. Okay? So no implied warranty on second-hand articles. If you are aware that that is a second-hand item, there is a caveat, di ba? Meron tayong tinatawag na caveat emptor. Di ba? Caveat emptor or let the buyer beware. Actually, you can use that in everything. You can, especially with regards to express warranty. Diba? Meaning, yung mga salesperson na yan, they are good at talking. Diba? Meron tayong tinatawag na sales talk or dealer talk. Of course, because their purpose is to sell to you their product. The normal presumption there is the buyer has the responsibility to be aware, to be cautioned of the representations of the seller or the salesperson. Caveat emptor. Article 1563, in case of a contract of sale of a specified article under its patent or other trade name, there is no warranty as to its fitness for any particular purpose unless there is a stipulation. This is in consonance with Article 1562, meaning that the only implied warranty that one can have is with regards to its ordinary purpose or general purpose. Okay? Ganyan lang yung Article 1563. Article 1564, an implied warranty or condition as to the quality or fitness for a particular purpose may be annexed by the usage of a trade. Of course, this is in relation to Article 1563 and 1562. Okay, meaning, then what is the known use of that product or that thing should be fit for what is supposed to be used. Kumbaga, ano talaga yung gamit niya, dapat fit siya for that purpose. Okay? That's Article 1564. Article 1565, in the case of contract of sale by sample. If the seller is a dealer in goods of that kind, there is an implied warranty that the goods shall be free from any defect rendering them unmerchantable, which would not be apparent or reasonable examination of the or unreasonable examination of the sample. Meaning, since you presented a sample of the product, di ba? Pinresent mo yung sample ng product. Therefore, ibig sabihin na yung sample na yan is the same as to what you are going to really sell. Therefore, there's an implied warranty on you as the vendor na talagang yung pinapakita mo sa amin na sample na yan is yan talaga ang ibebenta mo. Okay? Kasi kung hindi ganyan ang ibebenta mo at later on, hindi pala to yung sinasabi mo with regards to its features or yung mga selling points niya, then therefore, a vendor can be liable under the warranty of merchantability. Meron siyang implied warranty. Okay? Article 1566, the vendor is responsible to the vendee for any hidden defects in the thing sold, even though he was not aware thereof. Okay? The vendor is responsible to the vendee for any hidden faults or defects in the thing sold, even though he was not aware thereof. Okay? So, good faith, therefore, is not a defense for the vendor. Meaning, even though the vendor is not aware of that, because he sold the property, he guarantees that that is fit, that's of quality. Diba na wala siyang hidden defects. Therefore, whether he knows it, he has knowledge, or he has no knowledge, or he doesn't know it, it will not excuse him from his liabilities. This provision shall not apply if the contrary has been stipulated and the vendor was not aware of the hidden faults in the thing sold. Okay, so under the general rule, whether the vendor knows of the hidden defects or not, the vendor will be liable. Okay, except, okay, there is a contrary stipulation and vendor has no knowledge. Okay, meaning, if there is no stipulation with regards to the vendor's liability, okay, he is liable whether he knows it or he doesn't know of the hidden defects. We're talking about hidden defects. Okay, but if there is a contrary stipulation, why? Because we are under civil code, and when we say civil code, the agreements of the parties become the law between these two parties. So if these two parties contrary stipulated to Article 1566, then therefore, if the vendor is not aware of that, the defects in the vendor may not be liable. Okay? Take note, that's Article 1566. 1567, the vendee may elect between withdrawing from the contract there are two remedies daw, withdrawing from the contract plus damages and demanding the reduction plus damages. Okay? So, ibig sabihin, in case of warranty against hidden defects, okay, which covers 1561, 1562, 64, 65, 66, yung kanina, okay, may dalawang remedies si vendee. What are those? He can withdraw from the contract plus damages, ibig sabihin, hingi siya ng bayad, ng monetary consideration. Or he can demand a reduction of the price plus bayad, but in either case. That's Article 1567. Okay, it applies to warranty against hidden defects. So from 1561, 62, 64, 65, 66. Okay, Article 1568, if the thing sold should be lost in consequence of the hidden faults and the vendor was aware of them. So the thing is lost and the vendor is aware of the hidden defaults, okay, or hidden faults or hidden defects. He shall bear the loss, the vendor shall bear the loss, and shall be obliged to return the price and refund the expenses of the contract with damages. So, in summation, the first sentence of Article 1568 speaks about when the thing has been lost, okay, because of a hidden fault or hidden defect, okay, wherein the vendor is aware thereof or has knowledge thereof. He shall, number one, bear the loss. Number two, obliged to return the price and refund the expenses with damages. That is the first paragraph of Article 1568. Okay, if the thing resulted in the loss because of the hidden fault or defect and the vendor has knowledge, therefore the vendor is in bad faith. When we say that a person is in bad faith under the civil code, he is liable for damages. Therefore, he will not only bear the loss, he will also return the price and refund the expenses with damages. If he was not aware of them, he shall only return the price and interest thereon and reimburse the expenses of the contract that he might have, that the vendee might have paid. So, this is what you have to take note when there's a hidden defect and the thing is lost because of that hidden defect, then the vendor is liable under this line. Okay? Article 1569, if the thing sold had any hidden fault at the time of the sale and should thereafter be lost. Yung kanina, the thing is lost because of the hidden fault or the hidden defect. Dito naman, the thing is lost because of the fortuitous event or because of the fault of the vendee or the buyer. Okay, ano ang mangyayari? The vendee may demand of the vendor the price of which has paid less the value which the thing had when it was lost. So, if nawala ang isang bagay or considered, hindi naman nawala, considered as lost, meaning pwedeng naging lost na siya kasi hindi mo na siya magamit. And if it is considered as lost because of hidden defaults, 1568 is your legal basis. If it is lost because of fortuitous event or because of the fault of the vendee himself, then 1569 is your legal basis, meaning that the latter or the vendee may demand the vendor the price which he paid less the value of the thing which it had when it was lost. Okay? If the vendor acted, of course, sabi ko kanina, dito kasi ang sabi niya, vendor is in bad faith, he shall be liable for damages. Of course, basta na sa civil code kayo, kahit ano pang subject yan. Any party in bad faith, basta mayroong bad faith yan, basta kahit sino sa civil code, basta may bad faith, that person in bad faith is liable for damages. Okay, that's Article 1569. (1570). Of course, the preceding articles from 1561 to 1569 is also applicable to judicial sales. We already know what judicial sale is. Okay, a sale or an auction ordered by the judge towards the sheriff to conduct a sale. Diba? Except that the judgment debtor shall not be liable for damages. Why? Because there can be no bad faith. There can be no bad faith under a judicial sale. Why? Because it's the sheriff who will facilitate the sale. Yan na, yung sinabi kong prescription a while ago with regards to hidden defects. Okay, 6 months. Okay, 6 months ang prescription niya to file for warranty against hidden defects from the delivery of the thing sold. Okay, if it's a hidden defect, of course, kahit pa from the delivery, you can reason out that you only discovered the hidden defect just recently. Pwede. Now, we're done with warranty against hidden defects on things. Meron naman tayong hidden defects on animals. We don't call them hidden defect or hidden faults. We call them redhibitory defect. Redhibitory defect, yun yung tawag. Okay. What does Article 1572 say? If 2 or more animals are sold together, whether for a lump sum, isang buong price, or for a separate price for each of them, okay, per animal is ibang presyo, the redhibitory defect of one shall only give rise to its redivision and not that of the others. What does that mean? Okay, under the first phrase of Article 1572. Meaning, let's say for example, nagbenta ka ng, pardon me for my drawing. Yeah. Nagbenta ka ng 2 kambing. Yan, 2 kambing. Okay, lump sum ang presyo. Ang ibig sabihin nito, kung merong defect daw o redhibitory defect yung isang animal, ang redhibitory defect na yun will only pertain to him. Hindi madamay si kasama niya na animal. Okay? Ito lang. Siya lang daw ang may defect. Yan ang sinasabi ni first phrase or first paragraph o first first part of the first sentence of the first paragraph. Okay, meaning the redhibitory defect 1 shall only give rise to its redhibition and not that of the others. Kung siya lang yung may defect, siya lang yung may redhibitory defect. Wala ito. Okay? Unless it should appear that the vendee would not have purchased the sound animal or animals without the defective one. Meaning, this is only the general rule. Okay? What again is the general rule? That a redhibitory defect of one animal in the sale of 2 or more animals will only pertain to its redhibition and not that of the others, except or unless that the vendee should not have bought, okay, the animal with no defect, okay, without the other. Diba? Kung gusto niyo talagang bilhin ni vendee is yung dalawang hayop na yan, okay, then hindi pwedeng i-apply ito. Then therefore, in this case, pwedeng dalawa sila may be considered as both with redhibitory defects because they are treated as one. Diba? Kasi nga, kung hindi ko makuha yung isa, hindi nabibili ni buyer. Kahit pa yung isa is malinis, kung ayaw niya na yung isa lang, gusto niya yung dalawa, they can be considered as both animals having redhibitory defects. Same case here, the latter case shall be presumed when a team, a yoke pair, or set is bought, even if a separate price has been fixed for each one of the animals composing the same. Meaning, because you are intending to buy them as a pair or as a set. Diba? So if yung isa dyan may redhibitory defect at ayaw nang ibenta, hindi mo lang bilhin kasi nga ang gusto mong bilhin is sila na team or sila na set. Okay? That is redhibitory defects. The provision of the preceding article meaning 1572 yung kanina. Ito. With respect to the sale of animals shall also be applicable in the sale of other things. Okay? So it will apply to sale of other things. Meaning that if 2 or more things are sold by a lump sum price or if separate price pero they are sold together. Okay? Kung mayroong sira yung isa, pwedeng i-cancel ni vendee yung buong sale or pwede niyang tanggapin yung buo. Okay? Parang gano'n yung sinasabi niya sa 1572. 1574, there is no warranty against hidden defects of animals sold at fairs or public auctions or of livestock sold as condemned. Okay? Take note, generally, there's warranty against hidden defects on animals, meaning redhibitory defects, except if they are sold at fairs, public auctions, or livestock as condemned. Okay? In those cases, walang warranty against redhibitory defects. 1575, the sale of animals suffering from contagious disease. So if yung animal na nabili mo later on is suffering from contagious disease, that sale under 1575 is considered as void. Okay, void. A contract of sale of animals shall also be void if the use or service for which they are acquired has been stated in the contract has been found to be unfit. Therefore. Okay? Ibig sabihin, bumili ka ng kalabaw para magamit mo sa saka mo. Okay? Pero yung kalabaw na ito, ubod ng tamad at lagi lang nakaupo. Or lagi lang siyang nakahiga sa damo. Nung pinick up niya siya, nung i-deliver sa inyo, nakaupo. Okay, nung binaba nyo from the truck dun sa nilipat nyo na sa property nyo, nakaupo. Nung gagamitin mo sa saka mo, nakaupo, ayaw tumayo. Okay, then that sale can be considered as void because the animal is unfit. Unfit siya. For the purpose from which it has been bought. Okay. Pero kung bibilin mo yan dahil kakatayan mo, talaga na fit na yan, di ba?
Sir, pwede magtanong po?
Yes, Mr.
Um, about po dyan sa ano po sa Article 1575 po, is there some type of ano po standard or like ano po para po malaman kung unfit po yung hayop?
What do you mean? With regards to the second
Is it
paragraph?
judged? Yes, sir. Is it judged objectively po, sir? Is there an
Ayan, ang
objective?
sabi niya dyan, if we can read again the paragraph 2 of 1575, it shall also be void if the use or service for which they are acquired has been stated in the contract. Okay? When we say contract, okay, balik tayo . When we say contract, a contract could either be written, they could either be oral. Of course, in sale of these goods, ayan, di ba, mostly these sales are not in written. Mostly kapag nag-uusap yung buyer and seller, sabihin niya, bibilin ko para sa saka or para gamitin ko for my farming. Okay, yun na yung use na sinasabi natin na na-state dun sa contract. Okay, whatever stated, kung ano yung pinag-usapan nila, of course, yun yung magpre-prevail. But if wala, then what is the basis? Then wala. Okay? So kung wala namang sinabi na gagamitin niya for saka niya, then we have no basis. Okay? Clear ba, Mr. Amos? So kung sasabihin niya naman, bibili ako ng kambing, okay, dahil fiesta namin, what is the purpose? What is the use? Para katayin. Okay? Kung hindi makatay, unfit yan. Okay. Ayun, ganoon lang naman yung sinasabi ni Article 1575, second paragraph. So,
Yes, sige po.
our basis will be what is stated in the contract or what has been agreed thereto. Kung ano yung sinabi ni buyer na panggagamitan niya dun sa hayop. Okay? Clear?
Yes, sir. Thank you po.
Yes. Article 1576. If the hidden defect of animals, even in case a professional inspection has been made, should be of such a nature that expert knowledge is not sufficient to discover it, the defect shall be considered as redhibitory. So, Article 1576, ewan ko kung bakit ganito yung pagkaayos ng batas na dapat ito yung nasa una. Okay? Kasi it gives you an idea of what we call a redhibitory defect. Okay? Pwedeng maging redhibitory defect daw if even if there is a professional inspection and that expert knowledge is not sufficient to discover it, pwede siyang maging redhibitory defect. Take note, this is different from 1575 which we say na contagious disease. Iba yun, contagious disease sa redhibitory defect. Okay? But if the veterinarian, through ignorance or bad faith, of course, ulit-ulit natin sinasabi, di ba? Ayan. If the veterinarian, through ignorance or bad faith, although under this case, hindi lang bad faith but ignorance pa, okay, should fail to discover or disclose it, he shall be liable for damages also. Take note, automatic yung sinasabi natin damages, no? Pero under the law, You cannot presume that the person is operating under bad faith. Under the law, it is presumed that the person operates in good faith. Di ba? Of course, if you are going to allege that that person is operating under bad faith, then you have to show proof that that person is really operating under bad faith. Okay, kaya kapag na-prove mo na bad faith siya, you can claim for damages. Okay? Article 1577, the redhibitory, this one talks about prescription. The redhibitory action based on the faults or defects of animals must be brought within 40 days. So take note, hindi siya months, hindi siya years. 40 days lang sa redhibitory action. From the date of their delivery to the vendee. 40 days from delivery to the vendee. Okay, that's the prescriptive period. This action can only be exercised with respect to faults and defects which are determined by law or local customs. Okay, or as provided under this code. Okay. Article 1578, if the animal should die within 3 days after its purchase, the vendor shall be liable if the disease which caused the death existed at the time of the contract. Take note, no? Kung namatay daw yung hayop na binili mo within 3 days after the purchase, okay, then the vendor is liable. Pero hindi automatic, guys. Nakita niyo yung tenor ng Article 1578. Sabi niya, vendor is liable if the disease which caused the death existed at the time of the contract or at the time of the perfection of the contract. Okay? That's why, ngayon, kung ikaw ngayon, may binili ka na yung mahal na baka or kalabaw, namatay within 3 days. Okay, after mo nabili. Nagulat ka, ang sabi sa'yo, healthy. Okay, nagulat ka within 3 days or on the second day, namatay bigla yung baka o yung kalabaw. Under the law, ang sabi niya, liable si vendor. Pero may if siya ng provision. No? Ibig sabihin, you have to prove in court that the disease which caused the death of that animal existed at the time of the contract and not subsequently. Meaning, let's say for example, ito yung date of the contract. Okay. Ang sabi ng Article 1578, you must prove that the disease which caused the death existed at the time of the contract. Meaning, before pa siya na i-transfer sa'yo, meron ng disease. Okay? Kasi kung after lang yan, or 1 day or 2 days, or 3 days lang yan nag-exist na nasa iyo na, okay, then, hindi ka makaklaim kay vendor. Only when you can prove to court, and it will be dependent on the circumstances and the facts availing to the case. Okay? Depende lang kung paano mo irarason sa korte or paano mo ipoprove sa court na that disease has been existing at the time of the contract. Pero kung hindi mo siya ma-prove, you cannot claim from the vendor. Okay? But under Article 1578, you can claim from the vendor provided you can prove that the disease existed at the time of the contract. 1579, if the sale be rescinded, the animal shall be returned in the condition in which it was sold and delivered. Meaning, just like when we rescind in terms of property or yung thing, di ba? Yung discuss natin kanina, kapag you went for the remedy of rescission, you are to return the thing, di ba? Of course, you are to return the thing at the exact state kung paano siya na-deliver sa iyo. Diba? Ganun din si animal. Kung paano siya dineliver sa iyo, the animal must be returned in the condition in which it was sold and delivered. Okay? The vendee being answerable for any injury due to his negligence and not arising from the redhibitory fault or defect. Meaning, let's say for example, na-deliver sa'yo isang baka na may 4 na paa. Tapos pinakancel mo yung sale, nirescind mo yung sale. Pagbalik mo sa seller, wala nang isang paa. 3 na lang yung paa niya. Okay, because of your negligence, okay, then you are answerable, meaning you can be subjected to pay for kung magkano man yung paa ng baka na yan. But, if let's say for example, nawala yung paa na yan because of a redhibitory fault or defect, then hindi ka answerable. Yan sinasabi ni Article 1579. Okay? When you exercise your remedy for rescission, okay, you must return the thing that has been delivered to you. In this case, you must return the animal that was delivered to you in the same state or in the same condition when it was sold and delivered to you. If thereafter there has been an injury to this animal, and this injury is caused by virtue of your negligence, or in Tagalog, sa kapabayaan mo, you are answerable as the buyer. You are liable. But if this injury is brought about by the hidden defect or the hidden fault or the redhibitory fault, okay, then you are not answerable, or you are not liable as the vendee. Okay, that is Article 1579. Okay, second to the last article. In the sale of animals with redhibitory defects, the vendee shall also enjoy the right mentioned in Article 1567, but he must make use thereof within the same period which has been fixed for the exercise of redhibitory action. This article speaks of 2 things. Okay, it talks about remedies and prescription. Okay, meaning you shall enjoy the same right as mentioned in Article 1567. What is mentioned in Article 1567? That the vendee, in case there is a redhibitory defect kasi animal ito, the vendee can withdraw plus damages. This one I have discussed kanina sa 1567. Or reduce the price plus damages. Okay? These are the remedies of a vendee in case of a redhibitory defect in the animal. Provided that these remedies may be exercised within the same period which has been fixed for the exercise of the redhibitory action, which we have discussed a while ago as within 40 days, diba? From the delivery of the animal. Diba? Within 40 days from the delivery of the animal. That is the only time that you can exercise both these remedies. The last article, the form of sale of large cattle shall be governed by special laws. Meaning, with regards to the principles and to the essence of the sale of large cattle, the civil code is still controlling. Okay. Okay pa rin yung didiscuss natin kanina. Provided meron lang siyang form. Okay, meron lang siyang form. Yung mga large cattle kasi na yan, prone yan na manakaw. Kaya meron din silang parang property din sila. Sabihin mo na, parang tao din sila na para silang merong birth certificate, meron silang registration, meron din silang papel. Okay? Hindi ka pwedeng benta or mag-transport or mag-deliver ng malalaking cattle without these proofs na meron kang binili or wala. But I believe this is provided, ang special law nito is the anti-cattle rustling law. Anti-cattle rustling law. Okay, because madami noon ang kinukuha ng mga baka-baka kasi nga sa kalsada lang sila. Okay, that ends the obligations of the vendor. So next meeting, we'll proceed with the obligations of the vendee, the other party. Okay, so before I leave, any questions?
Sir, yung about sa caveat emptor po ba yun? Nabanggit niyo po sir na dapat malaman ni buyer po yung kung meron mang defect or man.
No, hindi naman.
Yun
Kasi
po ba yun, sir?
ang caveat emptor with regards to the principle na let the buyer beware, okay, does not really apply to implied warranties. It applies to, sabi ko kanina, it applies to express warranties yung sa mga sales stock or sa dealer stock ng mga salesperson. Okay, because of these words or these convincing words na hinayaan mo magsalita itong salesperson, there are tendency because of their exaggerations na, totoo ba? Papa-question ka, di ba? Kasi what they are selling may be too good to be true, yung mga binibenta. Okay, that's why as part of caveat emptor, even if ganun ang sinasabi sa iyo ng salesperson, you have to be precaution. Diba? Parang mag-ingat ka pa rin. Hindi porket sinabi niya yan, ganyan na talaga. Siyempre, i-try mo din, i-test mo din, or mag-research ka rin. Ganun with regards to the thing or the product. Okay, don't rely, meaning ng caveat emptor, don't rely solely on the dealer stock or dun sa sales stock mo sinasabi. Kasi if you rely on that, then tendency is maniniwala ka pa, bibili ka, and therefore you will believe na yung kung anong sinabi niya is yun totoo, hindi pala totoo. Okay, kaya meron tayong caveat emptor. Let the buyer beware. Okay?
Sir, one last po. Pasensya na.
Sige.
Sir, paano po pag visible po pala yung defect pero na-overlook lang po ni buyer?
Mayroon na tayong term dyan. Na-discuss ko na yan kanina, di ba? If visible, hindi siya pwede. Okay. Yun lang, na-overlook niya eh. Kaya these things are the things that you bring to court and then you prove them later. Okay? Kaya if totoo na na-overlook niya yan because of siguro minadali siya ni seller or something, yun, pwede mong i-describe or i-present sa court. Okay, but theory-wise, since we are studying the theory, okay, kapag patent yung defect, na meaning reasonable na makikita mo siya kaagad, visible siya, okay, then wala kang sinasabing hidden defect. You cannot claim for you cannot hold the vendor liable kasi nga mayroong defect. Kasi nga, in the first place, patent siya. Kitang-kita siya. Okay? With regards to yung sinabi mo na na-overlook, madaming circumstance yan eh. Paano ba niya na-overlook? Ano ba yung tinignan niya? Yung mga ganun circumstance, di ba? How much time does he have para tignan yung thing or yung bibili niya? Pinressure ba siya ng seller? Mga ganyang mga tanong. Okay, kaya it depends on the circumstances of the thing. Okay?
Yes, sir. Thank you po.
Sige, sige. Meron pa? Kung wala na, I leave you. Okay? Thank you for attending the class. Guys, good night. Sorry for extending the time. Okay, good night, good night.
Thank you po, sir.
Okay, sige, sige.
Thank you, sir.
Sure. Thank you
Thank you,
po,
sir.
sir.
Okay, good night.
Thank
Thank
you,
you po,
sir.
sir. Thank you, sir.